Happy Monday, and welcome to another episode of Cases That Should Have Gone to the Supreme Court of Canada, but didn't. Today we're talking about the unauthorized practice of law. Cases that should have gone to the Supreme Court of Canada, but didn't. Mr. Mikalakopoulos was a former lawyer in Quebec who was then charged by the Quebec Bar for illegally practicing law after his law license had expired. Mr. Mikalakopoulos argued that he never received notification of the fact that he was, in fact, unlawfully practicing law, and he shouldn't have been subject to the disciplinary proceedings. He never participated in any proceedings in front of the Quebec Bar Association, ultimately arguing only after he was served with a notice that he'd been convicted of this offense under Quebec's civil laws related to the unauthorized practice of law, that he then challenged on the basis that he didn't get word that he wasn't practicing law lawfully. And in the circumstances, he asked the Supreme Court of Canada to consider what an administrative tribunal should do where somebody argues that they haven't been given proper process and proper notice of the process. And this case raises important issues because the unauthorized practice of law is such a significant issue that can have devastating consequences for people who fall victim to unauthorized practitioners, but also because unauthorized practitioners may be doing so inadvertently or unintentionally or in good faith or without understanding that they're actually practicing law, as opposed to providing general information that might be publicly available. The fulsome opportunity for people to respond to these allegations, especially because the consequences can be quite severe, should be given to individuals. And an explanation of what administrative tribunals are supposed to do, where somebody doesn't get notice of a proceeding that is taking place, also raises important issues that don't just affect the practice of law in Quebec and the Quebec rules, but also affect the interpretation of administrative law across Canada. It's no secret that administrative tribunals do make mistakes and that people sometimes don't get notice of their hearings. So shouldn't there be Supreme Court of Canada guidance to decide how these circumstances are supposed to play out and what is supposed to happen when there is a mistake made by an administrative tribunal that results in somebody not being heard, especially if there are no provisions in the statute that explain what to do in such circumstances as Mr. Mikalakopoulos was facing. Ultimately, the Supreme Court of Canada had a really interesting administrative law issue to grapple with here, and it missed the opportunity to do so. Hopefully other cases come before the court that will allow it to deal with this question of administrative law, notice of hearing, and participation in hearing in a way that further develops the law in this area. Cases that should have gone to the Supreme Court of Canada, but didn't. Thank you for tuning in to another episode of Cases That Should Have Gone to the Supreme Court of Canada but Didn't. I'm Kyla Lee at Acumen Law. Thank you to Brace and Bolt Creative for putting together these videos. Please like, subscribe, and share with your friends.